In this lecture, we look at the final element that we have to prove, that the claimant has to prove in order to succeed with a claim in negligence, namely the element of causation. Remember that there are three elements that the claimant has to prove in order to succeed with the claim in negligence. Firstly, the claimant has to prove that the defendant, whom we call the tortfeasor, owed the claimant, note the claimant, him or herself, a duty of care. Once that's proven, the claimant has to show that the defendant caused or breached this duty of care. And the final element is to show that this breach of duty actually caused the damage suffered by the claimant. Also at this point, very important to realize or to just remember that if you haven't suffered any damage in the form of either personal injury, psychiatric injury, or damage to property, you won't have a claim in negligence. So remember to just always add causation of damage to this element. So just to repeat, the claimant has the burden of proof to show on a balance of probabilities that the defendant's breach caused their damage. In other words, this means that the claimant will have to show that there's a direct link between the defendant's action, the breach of duty of care, and the damage suffered by the claimant. Another way of putting this is to say that the chain of causation between the action complained of and the damage suffered was unbroken. You'll see that in case reports and in judgments and in textbooks, writers very often talk about the chain of causation or the causal chain. It just means that link between the breach of duty and the damage that was caused. Now, the reason why I used a set of dominoes as my introductory graphic in this lecture is because very often you have a chain reaction. You have one domino causing another domino to fall, which causes in turn another one. And this is one of the issues that we have with causation. How far back do you actually go? And who do you hold liable if there are more than one possible causative events? We will get to that in a second. Causation is measured, if you have a look at the cases, the judgments in this area and textbooks, you'll see that causation is measured in two ways. Very often it's taken as one element, in other words, causation as an element that needs to be proven, and that element is then broken up into two different legs. Firstly, causation in fact and causation in law. Some authors see causation only as factual causation and then think about what some authors refer to as causation in law as a separate element on its own. In other words, they think of four elements. But in most of the cases, we think about causation as two separate kinds of causation. Firstly, causation in fact, and then causation in law. I will explain why we call them causation in fact and why we call the other one causation in law in just a second. For now, we will look at them in detail, but for now, just think about causation in fact as formulated, or you find out whether there was causation in fact by using a test which we call the but-for test, whereas causation in law relates to whether or not the result was too remote from the originating action. But we will return to that just in a second. Let's look at factual causation then to start with. Factual causation is exactly what it says on the tin. You have to prove that as a matter of fact, on the facts of the case, what the defendant did caused the claimant's damage. We do this by using what was called or formulated as the but-for test from the case of Cork versus Kirby-McLean. And I'll leave the facts of this case to you for self-study. What we do need to, or what the important thing is out of this case, is that the but-for test was formulated as follows. If damage would not have happened but for a particular fault, then that fault is the cause of the damage. If it would have happened just the same, fault or no fault, the fault is not the cause of the damage. In other words, what we have here is a simple process of elimination. If we take away the alleged causative factor, does the resultant damage also disappear? If so, then the causative factor actually caused the damage. However, if the damage remains, then it means that this alleged causative factor didn't cause the damage. It must have been something else. So read this paragraph again and make sure that you understand how it works. It's a simple process of elimination. This is very well illustrated in the case of Barnett and Chelsea and Kensington Hospital, a 1969 case. In this case, a night watchman arrived early in the morning at the defendant's hospital, suffering from nausea after having drunk a cup of tea at work. The nurse on duty telephoned the casualty doctor, who refused to examine the man, simply telling him that he should go home and consult his GP in the morning if he still felt unwell. The claimant, the man, however, died 5 hours later of arsenic poisoning. Arsenic being a very toxic poison. The widow of the man then sued the hospital in negligence, but the action failed. If we just go through the elements of negligence very quickly. Number one, duty of care. Did the hospital owe a duty of care to the patient? Yes. Number two, breach of duty of care. Did they fall under the standard of what we would have expected a reasonable hospital to do? On the facts, yes. So we have two of the required three elements of negligence here. The third element, however, is that the claimant had to show that this breach of duty of care actually, on the facts, caused the damage complained of. Now here, this wasn't the case. The breach by the hospital did not cause the man's death. Evidence showed that even if he had been examined, it would have been too late for any treatment to save him, and therefore it couldn't be said that but for the hospital's negligence, he would not have died. So the claim failed on the element of causation. The hospital's negligence did not cause his death. Usually, it's a pretty straightforward exercise, the factual causation but-for test. However, things aren't always that clear-cut and easy to prove. So some problem areas we'll look at just in a second, but remember, just let's step back for a minute and remember that the claimant has to prove that the defendant's breach of duty, as a matter of fact, caused his or her damage. That causal chain has to be unbroken. If the chain of causation remains unbroken, then the defendant is liable in negligence to the claimant. However, there are some problematic areas related to causation. Firstly, we have what we call an intervening act, or a novus actus interveniens. Technically speaking, this is a defense, so we will look at this again when we look at the defenses in a separate lecture. But an intervening act would be something that breaks that chain of causation between the action complained of and the damage suffered. Another area that is problematic in causation is where we have multiple possible causes of the damage. And these could be either one after the other, consecutive, or simultaneous, all there at the same time. So let's first look at an intervening act. An intervening act, or a novus actus, if it breaks the chain of causation, then the defendant is not liable, because in effect what this is saying is that it's not the defendant's action that caused the damage. It's something else, somebody else. So somebody else caused the damage, somebody else needs to be sued. A novus actus interveniens, if it can be shown by the defendant, is an effective defense for negligence. And an effective defense means that it is a 100% defense. It means no liability will result at all. We look at this in much more detail in the defenses lecture. Moving on to multiple causes of damage. It's useful to think of, this is a very problematic area of law, and the cases are not always consistent. So be aware of the fact that what I'm doing here is just trying to simplify things a little bit, but as the cases are not always very consistent, there's a lot of leeway for arguing something to either sides. But it's useful to think of multiple causes of damage and thinking of them as what happens in consecutive possible causes, one after the other, and then distinguishing that from cases where all of the possible causes are there simultaneously. Let's first look at simultaneously present causes of damage. And here, once again, I find it helpful to think of cases or to group cases in one group if there were only two possible causes, and then all the other more than two possible causes in another group. So let's first start with if we have only two possible causes. At this stage, think back to what is the standard of proof in civil cases. Remember, the standard of proof in criminal cases is beyond reasonable doubt. So it's as close to 100% certainty as possible. The prosecutor in a criminal case has a very difficult job. They have to convince the jury almost to the certainty of 100% that the accused is guilty. On civil cases, the standard of proof is on a balance of probabilities, which means that the claimant has to just convince the court that it is more likely rather than less likely that what the claimant avers is true. So this means, if you want to put it in statistical terms, you have to tilt the balance over 50%. It has to be more than 50% likely that what you are saying is the case. Now, if we've got two possible causes and it's impossible to clearly say which one of those two possible causes was the cause, then what do we have? We've got 50-50. And 50% is not enough. It has to be more than 50%. So what the courts have done was to throw a little bit of a lifeline to the claimant. Let's look at the cases and it will illustrate what I mean. If you've got two possible causes, it is indeed possible to be liable or to hold the defendant liable, even if what they did was not the main cause or the only cause of the damage. The first case that illustrates this point nicely for us is the case of Bonington Castings versus Wardlaw, 1956 case. Here, the claimant inhaled dust, a lot of dust at work. Now, part of it came from a non-negligent source and part from the employer's own negligence, poor ventilation. So two possible causes. The additional dust exposure materially contributed to the eventual lung cancer that the claimant contracted. And the House of Lords held that a claimant can succeed if the breach of duty by the defendant materially contributed to the injury, even where the harm had multiple causes. So the key words here were material contribution to the injury. Materially contributed to causing the actual damage. In a later case, McGee versus the National Coal Board in 1973, the House of Lords expanded on this And they found that if the breach of duty by the defendant materially increased the risk of getting the disease or the risk of being injured, then there would also be a case. In this case, the claimant contracted dermatitis, which is a kind of skin disease, after working in very dusty conditions and not being provided with showers by the defendant employer. So the House of Lords here extended the Bonington castings ruling, and it said that, or it held that where medical science cannot distinguish the precise cause, causation can be inferred if the defendant's negligence materially increased the risk of harm. Now let's look at more than two possible causes. In this instance, if we just play the statistics game again, if there were two possible causes, it could be 50-50, right? But if we've got more than two possible causes and it's not clear that one of these possible causes were more than 50% likely to have caused the damage, then we cannot have 50-50. So think about three possible causes and all of them equally likely. So the statistical likelihood of one of them causing the damage would then be 33.333%, which doesn't clear that 51% threshold for on a balance of probabilities. So in this instance, the claimant will have to prove which one of them actually caused the damage. The key case illustrating this is Wiltshire versus Essex Health Authority, a 1988 case. The claimant here, when he was a baby, went blind after being given too much oxygen when he was born prematurely. Now, this wasn't the only possible cause of his eventual blindness. There were up to 5 possible causes, including being given too much oxygen when he was born prematurely. Now, 5 possible causes, one of which he was complaining about, one in 5 means a 20% possibility, and that didn't clear the standard that was required. So the court held the principle from this case is that the claimant has to show on a balance of probabilities that the defendant's breach materially caused the injury. What about consecutive causes of damage? In other words, one thing causes another thing, which causes, or one thing happens and then later on a different thing happens. The general rule here is that we just strictly apply the but-for test. You have to find out which cause actually caused your damage. This is illustrated by the case of Performance Cars and Abraham, 1962, where the defendant damaged a car that already needed a full respray from a prior accident. So the claimants here sued the original crash caused damage, which needed a respray, and the claimant sued the original perpetrator, the original tortfeasor, and got a court order. But that court order couldn't be satisfied. So what happened then is later on there was a second crash and a respray would have been needed. But the court said since the same repair would have been necessary anyway, no additional loss was caused. So the defendant was not liable because the defendant here didn't cause any new or additional harm. The exception to this rule is to be found in the so-called mesothelioma cases. Mesothelioma is a kind of lung cancer that is caused by inhaling of asbestos dust. So asbestos is a fire retardant material that used to be used in a lot of settings, such as, for example, in buildings, because asbestos cannot be put or cannot be burnt in a fire. It was also used in various industries, such as, for example, firefighters had suits made of asbestos, etc. The horrible thing about asbestos is that inhaling even just one very small fiber, so small that you cannot even see it with the naked eye, can cause cancer, and this could happen very long after you actually inhaled the fiber. So it could be latent in your lung and nothing happens until, let's say, 20 years later, where all of a sudden it triggers mesothelioma. So it's a very invidious kind of disease. What happened in Fairchild and Glenhaven Funeral Services Limited was that the claimant developed mesothelioma after asbestos exposure by several employers during the course of his lifetime. And it's impossible, given the microscopic size of what is actually needed to cause mesothelioma, to pinpoint when exactly and during which employment he inhaled the fibers that actually eventually led to the mesothelioma. It's not scientifically possible to determine which exposure actually caused the disease. The court, the House of Lords, allowed recovery against all of the employers who had materially increased the risk, and it allowed recovery on a joint and several liability basis. Now, this is significant because it means that, let's say that there were 5 possible employers and 2 of them went out of business. The 3 of them that were left, or even just one of them, could be held liable for the entire damage. If it was several liability or proportional liability, it would mean that each one of them would only be held liable proportionately. But joint and several liability means that one can be held liable for the entire damage to the claimant. Now, this one person who were held liable could then turn around and ask for a contribution from the others, but that's not the problem of the claimant. The claimant can get their entire claim from the 1 or 2 or 3 defendants held liable. So the House of Lords here held that each negligent employer is liable on a joint and several basis when they materially increase the risk of an indivisible disease. So the court said the disease cannot be divided. It's one injury. The court also found that, yes, it is an injustice towards the individual employer who might stand very likely to be held liable for the entire damage when they only contributed partially to the damage. The court, however, found that this injustice that could arise from the imposition of liability on an employer is greatly outweighed by the injustice that would result if we denied redress to the victim. This case was not very well received by the insurance industry, as you can think, because this would mean that potentially you could be held liable for something which you only contributed to partially. So in the case of Barker versus Corris, 2006, the House of Lords again were confronted with similar facts to Fairchild. And in this case, the House of Lords held that liability should be several, in other words, divided proportionally according to each employer's contribution to the overall risk. So the court, therefore, in this instance, moved from joint and several to several or proportional liability. But this was overruled very swiftly by Parliament in England. So Section 3 of the Compensation Act 2006 takes us back in England and Wales to the situation that we had, or the principle that we had from Fairchild. In other words, joint and several liability. Section 3 of the Compensation Act 2006 in effect reversed Barker versus Corris, making each employer fully liable for the total damages in cases of mesothelioma. And this was confirmed later in Sienkiewicz versus Greif, where the claimant's mesothelioma may have been caused by the workplace or by background asbestos exposures. The court ruled that even a single employer can be liable if their negligence materially increased the risk. Therefore, the Fairchild exception applies to single defendant cases where the exposure materially raises the risk. We also need to look at cases where there's the loss of a chance, which happens very often in medical negligence cases. Now, the courts are reluctant to impose liability in this instance. Go back and have a little look at the courts on policy grounds being reluctant to, in the first place, put a duty of care on public authorities. But this is something different. Here we are dealing with the causation element. The causation element only comes in after the claimant has already convinced the court that there was a duty of care and the duty of care was breached. Now, if this breach of a duty of care led to the claimant losing out on the chance of recovery, once again, we are playing, or we need to play the statistics game, and we need to remember that the claimant still has to prove on a balance of probabilities that it is more likely rather than less likely that their damage was actually caused by the defendant's breach. To illustrate this, let's look at the case of Hodson and East Berkshire Health Authority. In this instance, the hospital failed to correctly diagnose a fracture that was suffered by the claimant when the claimant was a child. Later on, the claimant then developed problems with his hip, and it then turned out that there was a 25% chance that earlier treatment would have prevented the eventual injury to the hip. Now, 25% chance is not enough because the court said you had to prove that the recovery chance would have been more than 50%. This just once again comes back to the fact that the claimant has to prove on the balance of probabilities that the negligence caused the injury. And this was then confirmed later on in the case of Gregg and Scott, where a doctor misdiagnosed a lump in under the claimant's arm. And it turned out that this diagnosis reduced the claimant's odds of survival from 42% to 25%. Now, a 42% chance of survival, this is still not enough. If his chance of survival would have been more than 50%, it would have been enough to satisfy the standard of proof that was required. So in other words, this means that reduced prospects of recovery, where survival was already less likely than not, does not satisfy the standard of proof that we require in civil liability cases. This brings us then to the end of our discussion of factual causation. Remember, factual causation means the claimant has to prove on the facts, on a balance of probabilities, that the defendant's action caused their injury. We now move to the second part of causation, which is legal causation. Now remember, you have to start with factual causation. You have to first, as a claimant, prove on the facts that there was causation. However, once you've done that, it's not the end of the inquiry, because you still have to prove that even though, as a matter of fact, the defendant's action caused your damage, you still have to prove that this was foreseeable. And that is what legal causation boils down to. Legal causation says that the damage does not, or the damage cannot be too remote. It cannot be too remote or too far from the actual causative event. We call this legal causation because it's a question of law rather than a question of fact, meaning that even as a matter of fact, the negligence caused the damage. We could still say, or the court could still say, no, we're not going to allow negligence claim in this instance because even though as a matter of fact, the damage was caused by the defendant, the damage was too remote. Now, what do we mean by too remote? By too remote, we mean that the courts do not want to have a situation where you are not held liable for things that you couldn't have foreseen. We don't want unlimited liability for an unlimited number of events for an unlimited amount for things that couldn't have been foreseen. The court needs to draw the line somewhere, and the court draws the line here by using foreseeability. So this is policy consideration. We don't want to have potential limitless liability from a single causative event. It used to be that as long as you could prove that the defendant's action caused your damage, as long as your damage was the direct consequence of the breach, that was enough. And that was the principle from the case of Polaimus. Now, this direct consequence of the breach principle still applies to torts, where the torts are intentional torts. But for negligence, the direct consequences test has been overruled. And this happened in the case of the Wagon Mount overseas tank ship, the overseas tank ship case. There are two of them. The Wagon Mount number 1 is the one that gives us the test for remoteness. In this case, oil was negligently spilled into Sydney Harbour, and the oil remained on the water, and several days later, the oil was ignited, causing fire damage. Now, this fire risk was not readily foreseeable, and the Privy Council held that only the damage that was reasonably foreseeable could be recovered. So this case introduced for us the modern test for remoteness in negligence. Just to repeat, once you've proven as a claimant that the breach of duty of care by the defendant caused your damage, on the facts, you also have to prove that this was not too remote. And it would be too remote if it wasn't reasonably foreseeable by the defendant. So it's the test of reasonable foreseeability. Let's just look at a few further issues with causation. Now, once the court is convinced, or the claimant has convinced the court that the defendant had a duty of care towards the claimant, the defendant breached that duty of care, and this caused, as a matter of fact, and also as a matter of law, the damage that was suffered by the claimant. Then the claimant has proven their case. Once that happens, what then? Well, if you've proven your case like this, then the defendant is liable, and the defendant will then be liable to the full extent of the damage. This is what this rule means, the thin skull rule, also sometimes referred to as the eggshell skull rule, because it refers to clients or to claimants who might have a condition where they have very thin bones, or their skull is like an eggshell. It can be broken very easily. Now, if something happens to a person who's got such an eggshell skull, for example, and their damage is then much more than a healthy or a person without that condition would be, then the defendant is still liable for the increased damages. So this rule basically means that the defendant has to take the claimant how they find the claimant. So don't get confused. Don't apply the thin skull rule during causation. Right? So the foreseeability in legal causation does not mean that the defendant had to foresee the precise kind of damage. It just means that we're looking at a sort of a ballpark figure. So what does happen if it turns out that the damage is more? You are held liable for the entire damage. And this is illustrated very well in the case of Smith versus Leach, Brain and Company. In this case, the claimant was burnt or suffered a burn to his lip at work, and unknown to him, unknown to anybody, including the employer, defendant, he had a predisposition towards a certain kind of cancer, and the burn to his lip triggered the cancer. So the question was, what would the defendant be held liable for? Only the burn to the lip or the cancer that was actually triggered? And the court said the cancer that was triggered. The defendant has to take the claimant as he finds him. Then finally, there are two things that I'd like to include here. When we're dealing with causation, there are two shortcuts that might be useful to the claimant. The first is the principle of res ipsa loquitur, and the second is Section 11 of the Civil Evidence Act. So let's first look at res ipsa loquitur, which is Latin for, broadly speaking, the facts speak for themselves. This principle says that if the facts are so obvious that it would be ridiculous to try and prove them, you don't need to prove them. They speak for themselves. This would be something really, really obvious, such as the sun sets in the west. You don't need to go and prove the court of that fact. So the court will take the facts as proven, or they will make an inference on the facts. The leading case on this doctrine is Scott and London and St. Catherine's docks 1865 case, in which a man was walking along the docks at St. Catherine's and some bags of sugar fell on his head, causing him injury. The court inferred that there was negligence because such accidents do not occur without fault. Bags of sugar, they said, do not normally just fall out of the air. Somebody somewhere must have been negligent. It illustrates the doctrine of res ipsa loquitur, which means that negligence may be presumed where the facts speak for themselves. The requirements, however, are that you still have to pinpoint who were the defendant. So those bags of sugar falling out of the air, who was in charge of them? And there must not be any other reasonable explanation for the incident. The only cause that was possible at all should have been negligence. If those are there, then the facts speak for themselves and the courts will infer negligence. Another example where I don't even have to give you the facts is when Lord Denning held in Cassidy versus the Ministry of Health. The plaintiff is entitled to say, I went into hospital to be cured of 2 stiff fingers. I have come out with 4 stiff fingers, and my hand is useless. That should not happen if due care had been used. Explain it if you can. And then finally, Section 11 of the Civil Evidence Act. In terms of criminal liability, remember the standard of proof is beyond reasonable doubt. It's as close to 100% as you can possibly get. If there is the slightest bit of doubt, then the accused has to be acquitted, found not guilty. Now, very often we've got the situation where one set of facts leads to a criminal prosecution as well as a possible civil suit in negligence. For example, let's say that there was a drunk driver, and this drunk driver caused an accident and the claimant was injured in that accident. Now, this defendant could be held liable in negligence for the injury caused and could also be prosecuted for drunk driving. If the drunk driving charge is upheld, so let's say that this person, the defendant, is found guilty in a criminal case, that finding of guilt could be used in the civil case. And you don't have to then prove everything anew. You can take it as proven. If it was proved in a criminal case, then automatically it can be taken as proved in a civil case. Why? Because if something was already proved beyond reasonable doubt, then it includes being proven on, or having been proven on, a balance of probabilities. If something was proven to the standard of 99.99%, it's already proven to the standard of more than 50%. So Section 11 of the Civil Evidence Act, I give you the entire section here on the slide. You can read it for yourself. Basically, it means that if it was proven in a criminal case, it can be taken as proven in a civil case. Now, to summarize, causation in negligence can be split into factual causation and legal causation. For factual causation, we use the but-for test from the case of Cork versus Kirby McLean. And just be aware of problem areas, including multiple causes of damage, loss of a chance, the mesothelioma cases, and always remember the possible defense of a new intervening act or a novus auctus. Or legal causation, which comes into play after factual causation is proven. We use the test of whether or not the damage was too remote, which we get from the Wagon Mound #1 case. And that is basically what you need to know about the final element to prove in a claim for negligence.